I'll go with first, according to just how obviously it's set out in the program, Mr. Christo de Klerk from BlindSA.
How do we do this? Good morning, everybody. As you heard, my name is Christo de Klerk. I am from an NGO called BlindSA, a consumer organization of blind people. I serve in a volunteer capacity on the EXCO, where I am the chair of its Committee on Accessible Publications. Now, we strongly support the signing of the bill. Judge Zak has outlined the constitutional stipulations. I will mention a few others. He mentioned the right to equality in Section 9 of the Constitution, equality before the law. That is also the first right mentioned in the Bill of Rights. But in 2007, the government ratified the United Nations Convention on the Rights of Persons with Disabilities, which has several relevant stipulations. In Article 4 of the Convention, it unambiguously commits states, the state, to ensure and promote the full realization of all human rights and functional freedoms for all persons with disabilities. In Article 9, it states that it demands access on an equal basis with others to, among others, then, information and communications, including information and communications technologies and systems. Further then, in Article 21, it demands access to information intended for the general public, to persons with disabilities in accessible formats and technologies appropriate to different kinds of disabilities in a timely manner and without additional cost. Then, 4 years ago, our government accepted the white paper on the rights of persons with disabilities, and its Section 6.114 stipulates and demands access to information and communications, and the same section also demands that government must ratify the Marrakesh Treaty, which came into existence already in 2013. So that is the legal framework. Now, where do we stand with that? Ms. Joan Fubbs this morning mentioned that we are seeking a balance. So if we're seeking a balance, we have a tremendous imbalance between, on the one side, the deprivation of our rights to access to publications, as against the struggle on the other side to protect vested and commercial interests. Now, if we look at the imbalance, currently there is a huge book famine insofar as only, well, less than 0.5% of new publications are available and in accessible format to persons with visual disabilities. And of that, less than 1% of publications, we in South Africa have access to even only a fraction of those, because we have, 6 years later, not ratified the Marrakesh Treaty yet. This means that we do not have access to large libraries in other countries like North America, in United States and Canada, Britain, Australia, New Zealand. We do not have access to vast libraries of accessible books because we have not ratified Marrakesh Treaty. It takes long, often, to be granted copyright exemption to produce books in accessible formats. And we have the issue that the production of material in Braille is a lengthy and costly process, but now we have to recreate those Braille books or books in accessible formats that are already accessible, that we can get from other countries, but we are prevented from doing so by the fact that we do not yet have the copyright exemptions. So clearly, our rights are being violated. Much has been said about fair use. That is not my brief this morning, but I associate myself with what has been said, that there's been a lot of fear-mongering around the concept of fair use, and a lot of nonsense has been spoken about it. Inadequate consultation, my goodness, that is another myth. I've attended so many of these forums in the past 6 years. The opposers to the bill have vented themselves aggressively enough, often in meetings that I've attended. I say no more about that. If the bill should be signed, the effect it would have was that it would open the door to us to vast resources of publications to which we do not currently have access. It would alleviate our book famine. And I was pleased to hear that there are representatives from the presidency here today. We need you to convey to the president that we need him to sign the bill. Judge Zak has clearly outlined the route for him this morning. It's not a difficult thing for him to do. And every day he delays, he aids and abets the violation of our rights. We have waited long enough. We are fed up of waiting. We need to have access to publications the same as all of you. Please take the message back to the President. We are heartful. Thank you. Thank you.
Thank you, Christo. And our next panelist will be Mr. Maphila from SADTU. Whatever you're more comfortable with.
No, thanks. Program Director, Magope Maphila, the President of SADTU. Before I forget, the message is, Mr. President, sign the bill now. Tomorrow is too late. Inaction in itself is an action. So by not signing, you're actually perpetuating the status quo. So those who are representing the president here should deliver the message. Mr. President, sign the bill now. It has never happened before that we will all agree when there is a bill before us. Debates have raged, and what is left now is for the president to sign. Those who are saying that he must not sign, they're actually perpetuating the status quo. As SADTU, since our formation, we've always been about standing for society as a whole, and in line with our 2030 vision, we want to create a learning nation, and we are acutely and painfully aware that learner-teacher support materials are very expensive, and by signing this bill into an act, this would be drastically reduced and therefore giving access to information. In many instances, particularly in the lower quintile schools, a learner's ability to proceed to the next level is significantly inhibited by their inability to acquire required information on time. As a union in education, we view the Copyright Amendment Bill as an issue of social justice. We are advocating for an approach on the matter that will seek to prioritize the basic human right to quality public education. Despite whatever limitations that might be there, Mr. President, you are urged to sign it, and those that are saying that you must not sign, they have a recourse. And some speakers before me here have indicated that this is in any case destined for courts. So why delay the inevitable? So by breaking the impasse, you sign the bill into an act to set the ball in motion. Delaying the inevitable by not signing is not the way to go. The current Copyright Act does not feature the required tools such as the fair use principle, which would take into account exceptions that seek to create access to learning materials, particularly for the poor and those with disabilities. It is evidently not in tune with the development that have been characterized as the fourth industrial revolution. There is no bill, we emphasize once more, that everybody has ever agreed to. So against this background, no more delays. Sign the bill, Mr. President. That's SADTU. Thank you.
Thank you, Mr. Maphila, and then Mr. Jonathan Band.
Hello, I'm Jonathan Band. I'm an attorney in the United States. I represent library associations and also technology associations. And I'll just speak very briefly about fair use. Obviously, that's been a very controversial issue in the debate here. I could talk about fair use all day, and I can talk about it all day because it's obviously a very critical part of U.S. copyright law. And so it is one of the things that has been somewhat, whether it's amusing or frustrating or perplexing throughout my career, is how resistant U.S. media companies are to other countries adopting fair use. You shouldn't think that this issue is unique to South Africa. When other countries are trying to update their laws, they're obviously interested in what's going on in the United States because they see that we have a very robust entertainment industry, we have a very robust software industry, and so countries obviously are interested in seeing what is it that the United States does and what is it in our copyright law that has facilitated the development of these industries. And the first thing that sort of pops out is fair use. And so they're obviously interested in fair use. But certainly over the past 30 years, whenever another country is interested in fair use, the strongest and most vigorous opponents are the U.S. industries that rely on fair use in the United States. And it's really been sort of like a paradox. Like, why is it that they rely on it in the United States, they support it in the United States, but they so vociferously oppose it in other countries? And let me underscore, they do rely on it in the United States. I just a few weeks ago filed an amicus brief, a friend of the court brief, in support of Drake, the performer, the rapper, who was being sued for copyright infringement, and his defense is fair use, meaning he sampled some material from another singer, and his defense is fair use. And actually, his lawyers contacted the Library Association and said, oh, will you file an amicus brief in support of Drake, in support of a performer, talking about how his use is a fair use? And we were very happy to oblige, and we filed this amicus brief on his behalf, and it's still before the court. But large, whether it's software companies, entertainment companies, in the United States, whenever they're sued, the first defense they rely on is fair use. And so it's very odd that they are so opposed to having fair use in other countries. So you shouldn't feel special. They're not just picking on South Africa. They've done this everywhere. And again, to the extent that they're somehow saying, oh, there's something specific about South Africa that makes you particularly it makes it particularly inappropriate for South Africa. Don't believe that argument, because they say the same thing, whether it's Korea or the Philippines or Israel or wherever they have opposed it over the past 30 years. The other thing that's important is one of the arguments that is often made is like, oh, fair use is not appropriate for this situation. It's very rare. It's very unusual to have fair use. Well, let's again, that's not exactly accurate. Fair use is, of course, simply our flavor of fair dealing, which you have. And fair dealing, of course, comes from the English copyright law. There's fair dealing in one form or another in over 40 countries with over 40% of the world's population. Now, a lot of that's because of India, because they have fair dealing. But also this notion that, oh, well, fair use is so unusual because it has an open list and fair dealing is closed list. Well, that's not true either. A lot of countries have amended their fair dealing to include, to have an open list. And in fact, there's interpretations that the original English list was really not that closed either. So the point is that there is nothing unusual about fair use or fair dealing, that these are really very similar concepts. And again, there's nothing that is that extraordinary about it, and that should give anyone particular anxiety. The last point I want to make is that there's this sort of looking at what are the specific arguments as to why fair use should not be adopted here. One of the arguments that's made, and that's in the petition that the International Intellectual Property Alliance submitted to the United States government was, well, fair use relies on precedent, and of course South Africa doesn't have all the precedent on which to rely. Now that's sort of a peculiar argument, because then, of course, no country could ever adopt fair use because they don't have the precedent. But moreover, there is something called the internet, and all of the fair use decisions in the United States, they're all available online, and so a judge here can have as ready access to our precedents and the precedents from Singapore and Korea and Malaysia and Israel and all the other countries that have fair use, and Taiwan and Hong Kong. a judge here has easy access to all of those decisions. And not only that, but there are all kinds of tools like the Copyright Office. Our Copyright Office has prepared handy summaries of every single fair use decision. And there's an index, again, online. You just go to the Copyright Office website and you can get an index, you can get this access to this tool that gives you all this information about all these fair use decisions, for this notion that somehow there isn't adequate precedent really makes no sense, because again, South Africa could have access to these precedents, and then very quickly, within 10 years or even less, you'll have your own body of case law that is uniquely suited to your situation, building on looking at those precedents, but then developing your own precedents and your own concepts. But really, I think underlying a lot of this hostility that U.S. media companies have towards fair use abroad is, I think, a notion, a concern of abuse, meaning they trust U.S. judges. So they feel U.S. judges have gone to U.S. law schools and are not going to take advantage of this exception. But somehow there's this concern that foreign judges will abuse fair use. I mean, they don't say that, but I think that that's what's underlying it, is just sort of a general distrust for foreign judges. Now, putting aside whether there's a basis for that or not, I actually heard recently a very interesting rebuttal to that argument by Professor Jane Ginsburg. Now, Professor Jane Ginsburg is a professor at Columbia Law School. She actually tends to be very sympathetic to rights holders. She wrote a treatise about the Berne Convention with Sam Ricketson, and she also happens to be the daughter of the Supreme Court Justice Ruth Bader Ginsburg. But Jane Ginsburg is a very, very bright woman, again, very typically viewed in the landscape as pro-rights holder. So she actually supports fair use in other countries in general. I don't know if she's weighed in South Africa, but her view, and I think that this is really reflects a lot of wisdom, is that judges are going to be judges are pragmatic, right? And they're going to find a way to do what they think needs to be done in their country. And so what's happened in Europe, where there's many exceptions are very rigid, is judges there, because they don't have fair use, and they don't have the flexibility of fair use, have come up with other concepts such as proportionality. So they're like, well, it's okay to take it because it's not so bad. You're not taking that much, so it's not so bad. But the problem with a concept like proportionality is that it doesn't have, there's no principles, there's no framework. And so she would prefer that you have fair use with the factors and a framework for judges to apply, to be flexible, as opposed to just leaving it to the judge to sort of rely on his or her own discretion to sort of reach what the judge thinks is the right result. In other words, that the absence of fair use is actually more likely to lead to abuse than having fair use. That fair use is the more conservative approach. It is the approach that is more likely to lead to principled decision-making and balanced decisions and reasoned decisions than simply leaving it to a judge without giving the judge any flexibility, because that can ultimately lead to greater abuses. So I'll stop there, but thank you very much.
And then our last panelist, Dr. Chista.
Okay. I'm Chista, Takaingenhamo C Collins. I'm from UNISA, University of South Africa, Faculty of Information Sciences. Generally, looking at the proposed, the amendments, I find them worthwhile, especially for libraries, archives, museums, and galleries, whom we usually, in technical terms, refer to as the GLAM institutions, because they are more of memory institutions, since they are also institutions that deal with, providing for people's epistemological needs, as well as ontological and social needs. So, taking into account that when you look at section 20 on exceptions and limitations, we find that the bill in some way provides for what we can call an egalitarian model for the distribution of information, which will also ensure shareability of information, and which will also help to change the dialectical relationship whereby we, people of the South, have been more of like consumers of information, so that through working with libraries, we can also become prosumers or creators of content. Looking at it as well, we find that it also provides facility for interlending and document supply services, where library, through partnerships or comparative engagements, can be able to use technology to leverage the shareability of information. It also helps to promote and secure the national heritage of the country through legal deposit, considering that there are so many works done by people from South Africa that have been published elsewhere, and a record must be created that will ensure that there's an updated version of what is it that has been published by the people from around. So we also take note that it also helps to promote teaching, learning, and research, supporting teaching and learning activities through the provision of open access, open science, open research, data sharing, and also ensuring that there is inclusivity in as far as access to information. Because if we make reference to the Universal Declaration of Human Rights, Article 16, it provides for the right for everyone to have access to information. And considering that as a member representing a constituent of the GLAM, we do not discriminate. We are for an inclusive society whereby everyone matters. So when we look at the stipulations within the Act, we find that it's a progressive Act which also takes into account even the other aspects of work that galleries, libraries, archives, and museums do. For example, we have unique collections of what we can call sui generis works. These are maybe works from communities, indigenous knowledge works. And when you look into the bill, it also provides for those unique collections of works. So in some way, we can say that it is progressive because it has that propensity, or it provides for what we can call epistemic justice in as far as knowledge access is concerned. And it also takes into account the fact that as libraries, we also have the right to serve as information intermediators, repackage information, also serve as information consolidators and mediators, so that information can be repackaged. So through clauses on fair use and etc., we find that the Act itself provides for information reproduction, information repackaging. And this is also in line with the 5 principles of the open educational resources. For example, revise, the right to revise, remix, reuse, redistribute, and retain, which makes it much more progressive because it's like, what can we say? It's like we have been given leverage to rise above the limitations of the paywall, to rise above monopoly by the big 5 who control most of the publishing industry. So in some way, in a big way, we can say it helps to leverage the status of libraries and also rejuvenates them as we advance as we move within the knowledge economy and advance towards the 4th industrial revolution. And it is also useful to us in the sense that we not only serve as institutions providing for access to information by ensuring that information is identifiable, is locatable, is retrievable, is discoverable, retrievable, and shareable, but also ensuring that users of information have the right type of information, and they also have got the right to create content on their own so that we can also reposition Africa on the global knowledge and information landscape. So without the support of libraries, galleries, archives, and museums, such a noble goal would be very difficult to achieve. But considering this progressive act, I can say that, yes, indeed, it gives us a boost and strengthens our position as institutions that provide for democratic access or democratizing access to information, and also promoting shareability of information and ensuring that we develop an informed citizenry that will be able to contribute meaningfully towards the realization of sustainable development goals, Agenda 2063, and ensure progress for all of our society or communities. On that note, I think my presentation comes to its eclipse.
Thank you to all our panelists. I'm now going to open up the discussion to the floor. I'll take 3 questions at a time. It's really helpful if you please introduce yourself as a speaker. You can just click on the gooseneck mic in front of you, and then also who you're directing your question to if you're directing it to a particular panelist. If not, fear not, one of them will catch your question when you throw it out. First question noted.
Thank you very much. Thanks to the panelists. My name is Dimakatso. I'm from ICASA, the regulator. Basically, my question, I think, is directed to Jonathan. Because when people have been speaking about fair use, it has been in the context of, written materials, but I have not heard anything around circumstances under which one can invoke fair use, particularly in cinematographic material, or rather audiovisual material, because I just want to find out under what circumstances can one invoke fair use. And maybe just a brief distinction between fair use and fair dealing, because I think it's a very thin line that is there. Thank you.
Thank you for the question. Second question. Mr. Harris?
Sean Harris, representing Southern African Freelancers Association. The question is to Jonathan Band again on the fair use. Has South African history has already shown through the infringement of artists' work, not only photographers, but filmmakers and creators, that many of them do not go forward and challenge the infringement of their work simply because the litigation costs or any access to litigation is too high. And the infringer has said that not only under fair dealing in the past, but this is how they got access, and this is the reason why they've used it. The concern for the community out there, creative community, is that the length of time that it takes to find closure or even recompensation of one's infringed work. And free dealing in South Africa, we have shown under experience, does not work because of the length of time the artist, or the creator, has to go through the long steps and the long walk to get freedom and recompensation for his funds. So that's how they see it. I would like to know how, again, even though it's on the American model, it's easier to bring litigation into the system or in the US model against an infringer than it is in South Africa. These are the type of points that I would like to have more information on. Thank you.
And the third question?
Is it on? Okay.
Yes.
I'm Tabiseng Kotsokwani.
you mind?
I'm Tabiseng Kotsokwani. I'm the chairperson of the IFLA Africa section. I have a concern and a question. There's a bill that's sitting on the president's table for years that hasn't been signed, right? Secondly, our country hasn't ratified, I'm assuming, I think, the Marrakesh Treaty. Those are the two very important knowledge creation or the bills and what can I call them? Bills that would help us also to have, for our community to have access to information. Already we are a step behind on the digital divide, there is a digital divide in Africa. And we seem to be pulling everything else that will help us create knowledge. And our government is not helping. We are not ratifying the Marrakesh Treaty. We're not signing the bill. Is there, I don't know who will answer this, I don't know from the panel who will be willing to maybe put their heads on the chopping block and answer. How are we going then to go forward with the fourth industrial revolution? How are our people in Africa who already have issues with access to knowledge ever going to be at the same stage with the world? The US story about not getting access to fair use, or we shouldn't be using fair use, I just feel it's another one of those us being colonized again, you know? So I'm more concerned about the Marrakesh Treaty and the bill not being signed and being controlled and colonized again from outside. How are we going to be at the same stage with the world, especially the global south, as my colleague has just said?
Thank you for the question. To Jonathan, can I start with you since the first two questions were directed at you?
Sure, thank you. With respect to the first question, you have, there are many ways where audiovisual works can be subject to fair use. One of the clearest ways is if you're making a documentary film, right? There's many reasons why you would want to include pre-existing works in your documentary, and certainly those kinds of works, it could be still images, it could be text, but it could also be audiovisual works that you would want to include in your documentary. You would want to include little bits and pieces of earlier works. I mean, that would be relevant to the documentary film you're making. And so then certainly you have then mashups, right, or remixes where a person's creating a new work and but to create that new work they're using pre-existing works. There are many examples of that sort. Now you also had asked about sort of like the difference between fair use and fair dealing. So classically in the English law, I believe, of 1912, the English copyright law of 1912, it basically said something like, and this is almost I believe that your existing Article 12 is based on that, and it's sort of like, copyright shall not be infringed by any fair dealing with a work for purposes of research and private study, private use, purposes of criticism and review of the work, and reporting on current events. But what is a fair dealing is not defined, right? It's sort of open. And one of the advantages, arguably, of the fair use approach is so with fair use, we say the fair use of a work for purposes such as, so it's open-ended. It's not limited to the specific, research, private study, criticism, review, but it says such as, and then it has a lot of those same things. But then it lists 4 factors that a court is to consider. And that's a non-exclusive list, but it is 4 factors that guide the court's consideration. And so that, in that sense, it is, one could argue it's maybe more limited than fair dealing, because with fair dealing, it's up to the judge to say, is this fair or not? Whereas at least with fair use, you have the criteria, the guidance, what the court is supposed to be looking at. And so our 4 factors are the nature of the use, the nature and purpose of the use, the nature of the work, the amount used, and the impact on the market. Now those 4 factors, with slight alterations, are included in the new South African provision. But what you'll see in many countries, what many countries have done is again, these are all Commonwealth countries or former colonies like ours. They start with the fair dealing, the sort of the classic fair dealing from the English copyright law of 1912. And then they add additional purposes. So it's not just the original 6, but there's others added in. And then some of them have made it into an open list and say including or such as. So it's not just limited to those specific factors of purposes. A lot of them have, even though they still say fair dealing, they then add the fair use factors. They say in determining whether this dealing is fair, and then they have the U.S. factors. So it's just sort of a very interesting, sort of from a comparative law perspective. And so I did this project. I just gathered all of the fair use and fair dealing provisions from around the world and put them together in one handbook. And it's really interesting to see how they all start from the same place, and then over time they've all diverged in different ways, trying to figure out how do we allow the flexibility to allow the purpose of copyright to go forward, because certainly in the United States we talk about the purpose of copyright is to promote the progress of science and useful arts. We want to promote creativity, but all creativity is based on pre-existing works, right? Nothing springs out of anyone's head. Everything is based on what went before. And so you need to always figure out how can you use pre-existing works in a fair way that doesn't harm earlier, those creators. And that's, so that's what everyone's, in every copyright system, they're all trying to deal with the same problem, but in slightly different ways. Now getting to that gentleman's question about the challenges of enforcement of rights, I agree, that is a huge challenge. It is a challenge that authors face everywhere. But I think that certainly the top challenge is in the digital environment is sort of like the wholesale infringement, right? That is the biggest challenge I think that all rights holders face, and it's a challenge. I mean, there's no simple solution. Different countries are trying to come up with different ways of dealing with that problem. Litigation costs are a problem, and it's hard for the individual artist to enforce his rights. I'm not going to minimize that. Exceptions are a different issue. I mean, to be sure, you will have people who engage in wholesale infringement and they say, oh, this is really a fair use or fair dealing. You will have people who say that, but by and large, you know, they're not the real problem. I mean, the real problem are the sort of the old days of people making, just all of the, the selling the videotapes without authorization, and then the CDs without authorization, then the DVDs without authorization, and now it's the streaming sites. They're not trying to pretend that it's a fair use or fair dealing. They're just pirates, right? And piracy is a problem. But I think that trying to come up with balanced exceptions is not is a different issue. As we were hearing about, people with print disabilities or libraries, we're trying to come up with a way to address their needs without undermining the markets, without undermining the incentive for authors to create. And it's a challenge. It's a challenge to find the right balance. But I think, there's always going to be pirates out there, and they're a different issue, and pirates don't rely on exceptions. Pirates just pirate. And so that's why I think it's really important to try to keep the discussion separate. And also, it's like, the people from the blind community and the libraries, they're not trying to facilitate piracy, right? I mean, if a library is engaging in an infringing activity, it's really easy to find them, right? So they're always trying to do things in a conservative, balanced, fair way. So that's why it's important to really keep these, as much as possible, the discussion separate. Thank you.
Thank you for that. Before we go into two last questions that are popping up, anybody from the panel want to catch the third question?
Okay, no, you can go ahead.
Thank you. I mentioned earlier that I've attended several events like this, and in the past, those opposing the bill have been far more vocal, far more visible, far more noisy than those of us who support the bill. And I suppose that's been aided by the fact that they've got big money behind them. I would recommend that we who support the bill have to mobilize. We've got to become less polite, if I may put it that way. We've got to make sure that we are noticed, that our point is heard. Now, our organization, BlindSA, is at the moment seriously looking at litigation and going the Section 38 route. We have to show up the nonsense that is spoken by those opposing the bill. There's a lot has been said about fair use, that it is an evil imported from the United States, Now, if it is such an evil, how come then that more books than ever are being printed in the United States? From an index of UNESCO, in the year 2013 alone, in the United States, 304,912 new titles were published. And if you include self-publications, that would double the figure. Then the movie industry is flourishing. In 2018, 871 new feature movies were created in North America, and that's the second largest in the world, only after India. So, does that seem to you like it is such an evil thing? That's why I say there's a lot of fear-mongering going on and nonsense spoken about these things, and we have to point out those things. You know, it is cold comfort to us that PASA says they support the Marrakesh Treaty, they support the exceptions for print disabled persons, while they are delaying the process by fighting to protect their own vested interests. So, to answer the third question in brief, I think we just have to mobilize and be more vocal, more visible, and use whatever tools are available for us. Thank you.
Yep, mine is slightly more just a comment. I know there's one or two folks here who haven't been through these arguments 500 times, like some of us have. Lady from ICASA. One of the best examples of audiovisual fair use is in shows like Trevor Noah's The Daily Show, where, you know, he's showing clips of Fox News reporters up to their racist and misogynist nonsense, and showing those clips on his show. Can you imagine if he had to ask permission from Fox News to show clips of them being right-wing racists? They would either say no, or they would say, sure, it's going to cost you, you know, $500,000 per second to show the clip. So it's really important as regulators, you know, that you have your head around the importance of fair use. In fact, there are some pretty horrible, I don't know what to call them, like gentlemen's agreements between our broadcasters not to use each other's clips, or not to let producers use each other's clips. So as TV producers, we often come against a situation where we want to show a clip from ETV on SABC, we want to show a clip from, you know, Carte Blanche on ETV. Actually, we can do that already based on the quotation right in our law. Fair use will make it even better. But sometimes the broadcasters say, no, well, we don't really want them to use our footage because they might use it under circumstances we won't like, so let's not use their footage. But no, we need a properly regulated setup where if it's fair and if it aids freedom of expression, everybody can use it. Because if we don't have that, then there's political censorship that starts to come into play. And just to emphasize the point that Jonathan did mention, but just for those who are a little bit new to this, the fourth test in the fair use test says the following: if you substitute what you are doing in the market for the original work, it's not fair. So in other words, if Trevor Noah featured the whole of Fox News' news report and tried to put out his own news report by not paying the salary of a news reporter and just having Fox News reading the news on Comedy Central and trying to make money out of it, that would never be fair use. None of the uses, Sean, that historically have been the terrible examples of photos stolen. You know, the really famous cases where the Hector Peterson photo, you know, was used and abused and stolen. No one could ever have claimed that that was fair. That was a company taking a photograph, charging for its use, charging royalties, and not paying royalties back to the original person who took the photo. Never, ever fair. So I think someone already said, and just to clarify, it's better for those who are defending their rights as owners of their own work to have that four-step test and the definition of what's fair. Otherwise, pirates might say, but everyone does this. No, everyone doesn't do it if it's not fair. Let's have it on the books, what is fair.
I'll give you a chance, Mr. Harris, to reply, but before that, there was another question before you from the gentleman behind the camera.
Thank you. There's was that the lady that spoke about, or just we generally speak about the big five publishers, the international publishers, who seem to be a serious problem in our knowledge economy. There are big figures that are being told to us that they are going to them. So I wanted to just check, what are we, of that money or of that percentage or of the knowledge economy or the knowledge that is within our universities and learning institutions, how much of knowledge are we getting from the continent, academics and writers? Do we have stats for that? How much we are using our continental intellectuals and book
So
writers?
the African continent produces 1.1%, but looking at different statistics that's been written up, it's somewhere between 0.6 and 1.1% for the African continent, of which South Africa is the largest contributor.
Thank you.
Thank you. I will take, just for time's sake, I will take one more comment, and then I'll ask the panelists to maybe, if you have a closing comment, to wrap it up. And Sean Harris, I'll include your comment in the last round of comments. Thank you.
Thank you. My question is to Dr. Leti. I just want to find out what is ASAF's take, since they're doing advocacy for open access on the bill. What would be the advice that would give for academic libraries, since you know how much we spend? By the way, I'm Tabiseng from the Mangosuthu University of Technology in Indaba. Since we know how much libraries spend on budgets, and then we turn around and buy the same content that our academics, are publishing to these publishers. So I would like to know what is your take in terms of the bill.
Okay, so I think for answering that in a fair manner, I will answer it in my personal capacity as a researcher. As far as I know, Denise can correct me, the former Department of Science and Technology, now the Department of Science and Innovation, never made a contribution to the copyright bill. The Academy of Sciences also did not make a contribution. Yet, a bunch of these people are working together with USAF to work on a business model based on statistics from 2014, where the expenditure was close to 500 million rand. And I don't think that we have enough statistics, and I don't think that the statistics are correctly put together. And I'm also worried if one includes one of the big culprits, like your consortia manager, to be part of those discussions. So I think SANLIC is a part of the problem, because SANLIC does not do any legal or contractual changes. They don't look at the contracts that we sign. They only do an opt-in, opt-out business model. So yes, from a personal perspective, I think the department, as well as my own institution, has let me down severely, and all of us.
Thank you. Mr. Harris, your comment before we go into closing comments?
The point on free use, again, on artistic's works, or the photographer's, more importantly, his works. At the moment, there are a number of photographers out here whose work has been infringed on by the government. And I know of 4 major infringements of their work. The government had said that it is under free use, or you gave us the picture for one-time use. And then the government would go and reproduce that and say that it's free use and this is it. Not only that, because of the way that the government has handled or used a photographer's or creative's picture, other companies or other individuals are saying, well, because they've used it, we can use it as well. And the biggest dispute between the creator and the infringer, if it is the government or even the civil society, is how does one not only challenge that. I know that the South African, under the Act or the legal profession, has said that the new dispensation will look at creating specialist criminal courts, copyright courts or special tribunals under this. As you may know or may not know, that the criminal court in, special criminal court in Johannesburg has closed down. They've moved to south of Johannesburg now. Because of the shrinking legal fraternity, not only it into motion. Again, and I say that looking at my case, it's 7 years now, I've put in my challenge for the infringement of my work, and they've used every single trick in the book to turn around and negate it. It could go into 10 years, it could go into 12 years. In that meantime, when I'm saying that there was no free use here, all the other photographers are saying the same. As Ben has said, that there's no out there, because photographers and those creatives have not gone and challenged it. They've just walked away from it and said, that is the way it should be. The bill has to be changed, yes, and it has to be signed. But what we're looking at is a way that it would compensate. It would look at the way that photographers and those creatives are recompensated in a quicker manner than it has already been shown that those who would like to bring a litigation against the infringer were not left out in the wing for over a decade, just on one picture use or a multiple of picture uses. Thank you.
Thank you, Mr. Harris. And before I hand over to the panelists for closing comments, I would like to make a comment just based on that, is that there is one existing judgment in South Africa that deals with fair dealing and our current legislation. That's the MoneyWeb versus Media 24. And in that judgment, you'll excuse me, I can't remember the name of the judge, he lists 8 factors that determine what is fair dealing. He borrows largely from US jurisprudence, and one of the factors that I thought was quite interesting is that the 4 fair use factors are included in his determination of what is fair dealing. So he goes beyond that because obviously fair dealing isn't currently prescribed as to what that amounts to within our current Copyright Act, which is something that would change if we moved forward and we signed this bill. We would actually have a definition as to what is that use, and then important factor that Ben also mentioned, when it infringes on your economic rights as the creator of that work, it is not fair. And it's a pity because in the digital age with 4IR and technology growing as fast as it grows, there's a large amount of infringement, and we don't want to conflate the issues of infringement and compliance and copyright and technology. It's a big playing field. And I think also in terms of your question on royalties, our second panel that's coming shortly, we're trying to quickly run through time, will actually speak towards the royalty provisions that will actually help photographers and help creators earn more money off of their works after licensing, after assignment, et cetera, so that you're not waiting 10 years in the woodwork, 7 years, 15 years for you to be compensated for your works. But from my understanding, and I'm sure many in the room that share my legal mind and my legal thinking, the infringing work that you are experiencing is not protected under the current Copyright Act, nor is it going to be protected under the proposed bill. Closing comments. If you don't.
Okay, basically, I think the proposed bill is something more important, especially speaking on behalf of the GLAM fraternity, because in the previous one we didn't have legal flexibilities to cater for people with disabilities, to cater for GLAM, and to cater for other stakeholders. But in the proposed one, at least there is some room and provision for all these stakeholders. So to answer the other lady who was saying, when will we reach the level where others are? Well, having the proposed bill is good, but that's not the only factor, because there are other factors. For example, national information policies, national information infrastructure, access to internet and etc., and the provision of internet services by commercial internet service providers and non-commercial internet service providers, and how do we strike a balance? So there are also other factors to take into cognizance. Thank you.
Dr. Leti Klein? No comment. Christo de Klerk, any closing comments?
Thank you. I want to reiterate that we need the President to sign the bill. The flaws can be sorted out later. Nobody is saying that the bill is not flawed. If it were, it would probably be the first ever bill that was unflawed. If there has to be consensus about the bill before the President signs, we would have no Acts of Parliament. Please convey to the President we need this to be signed, and signed urgently, today if not tomorrow.
Thank you. Mr. Jonathan Band?
So I just wanted to quickly say that one of the things also to remember is, as this bill is being considered, is that in this current environment, it's wrong to think of, you have creators over here and users over here. We really are all creators and all users, that any act of creation requires using something that came before. And also, at this point, we all are, we all, with our smartphones, we all have the ability to create and distribute our works on a global basis. And so, the amount of creativity is increasing enormously, and we should make sure that the legal framework moves accordingly and adjusts accordingly, because as my colleague here was just saying, I mean, the number of works created of all sorts is far greater now than at any point ever in human history. And so we want to encourage that to continue, as opposed to come up with legal strictures that prevent that. But again, the main point is that, everyone in this room is a creator, and we shouldn't shy away from that.
Thank you. And Mr. Maphila?
Thank you, Program Director. From an education point of view, Mr. President, sign the bill into an act. If there are any amendments to be made, this will not be the end. There will always be a room, so sign. Thank you.
Thank you.